I'll talk about specifically on return, procedural safeguards, and the right to an effective remedy. You may see the quote that I've put up from Angela Merkel, and during the course of my presentation, it might become, I will enlighten you why I've used her quote. So I think it's a very important issue where, as we are all aware that there's a big influx, we're always looking at individuals and individual cases and vulnerable individuals. So, this one? No? Yes. I will start off talking on my presentation with Article 41 of the Charter. Why? Because I think it is a very important article and a very important principle, the right to a good administration, because that underpins what's happening within SEAS, the Common European Asylum System, and also the Returns Directive, which is, I suppose, at the end of it. Good administration also entails that as member states are in a position to actually determine who they have in front of them. You have asylum seekers, economic migrants, illegals, and if it all becomes a big mess and you're not sure who you're dealing with, then it becomes very, very hard for the safeguards which are there in secondary law, because remember Article 41 is primary EU law, to actually have full effect. Rights which are not effective are, in my view, not real rights. So you need a good administration, not just on behalf of the individual, but also for your own administration as government, because it also makes life a lot easier if you're dealing, for example, with Dublin, because then you actually know if this person had a residence title or a visa, or who this person is. Which will then bring me to the safeguards pending return. I'm making a distinction between safeguards on return and pending return, and I will end up with questions, hopefully from your side, and then we'll have a discussion. As I said, the right to good administration is a fundamental right. It's recognized as a general principle of the EU and is laid down in the Charter. It is important also within the matrix of the Returns Directive. Why? Because, as it says, the Returns Directive applies to third country nationals. Well, that's quite clear. Is it? You know, if somebody says they have a passport or they've obtained a certain nationality, but it hasn't been properly registered, you don't know. Staying illegally on the territory of a member state. Illegally is a term which is quite difficult because in many countries, and I'm not going to just target today Greece and Italy because that's countries which have to deal with a lot of numbers of people, but also in other countries where I've been active in the Balkans and so forth. It is entirely not clear whether these people have actually asked for asylum, if these people have want to ask for asylum, and whether these people are eligible for protection. When I was in Serbia about half a year, no, maybe a bit longer ago, I spoke to a few border guards because I was on a mission, and they said to me, you know, if a Syrian comes here and doesn't ask for asylum, for me, he's an illegal. I'm going to lock him up. And then I said to them, well, yes, but you know, I can understand that. But these people want to move on to Germany, Austria, and so forth. He says, well, as far as I'm concerned, if they don't ask for asylum, they're illegal, and I'm going to treat them as such. And I asked, well, you know, what are you going to do with them? Well, you know, send them back to Hungary or send them back down. It's very easy for academics and lawyers to point the finger at this border guard. But just think about it. If the good administration is not there, if the queues are so huge to ask for asylum, then why should you blame a border guard who can't see, you know, by the look on somebody's face whether they're an asylum seeker or not? And again, you know, I think it's very important that without a proper application of 41, we quickly run into problems. And the European Court in Luxembourg has clarified a number of times that Article 41 applies even if it is not expressly specified in legislation. So it's an underlying principle. It underpins, I suppose, the rule of law. And we'll look at the case law involved that. I'm going the wrong way again, aren't I? Right. The right to be heard is one of the most important procedural safeguards in the Returns Directive. It may be included in the asylum procedure, the court has said. So in other words, there's no need for an autonomous, separate right to be heard or interview under the Returns Directive, with the rationale being that in the asylum procedure, we're looking at non-refoulement, which is central in the asylum procedure. And non-refoulement is all about what will happen to this person if he is returned or not. In other words, the court was quite clear and said that if you have an asylum interview which encompasses all of these elements, then there's no need to have a separate interview regarding the return. Conversely, and however this is also what the court said in the Mukara Bega case of November 2014, it considered that the right to be heard before the adoption of a return decision cannot be used in order to reopen indefinitely the administrative procedure for the reason that the balance between fundamental rights concerning the right to be heard before the adoption of a decision adversely affects the person, and the obligation of the member states to combat illegal immigration must be maintained. In other words, what the court is trying to get across is that his positive individual right, namely in this case the right to be heard, cannot be used by administrations as a mere facilitator to make sure or in order to window dress what is called the reopening indefinitely of administrative procedures. These are rights of the individual. These are not rights which can be used by administrations. And I think it's very useful to remember this point. Again, in the Bourgi-Lida case, which was a month later, the court considered in paragraph 47 that consequently the purposes of the right to be heard before the adoption of a returns decision is to enable that person concerned to express his point of view on the legality of his stay, on whether there are any exceptions. Article 6.1 of the directive as laid down in Article 6.2 and 5 are applicable. Right. Article 5, it basically says you've got to look at best interest of the child, whether there are family connections, whether somebody is seriously ill, and non-refoulement. These are the 5 exceptions and 4 exceptions in Article 5. And 6.2 says that, for example, if you have a third country national who has a Spanish residence permit and he's caught in France, or he's arrested in France, he ought to be able to return to Spain if it's still valid. Again, this can be seen in an antagonistic way, but you can also see it in a positive way. In other words, the national authorities, if they are not aware that the person has children, or whether, when in the case of an unaccompanied minor, has parents in another country, why would you not want to send an unaccompanied minor back to whatever country he comes from if you know that he's got parents? You don't want to send back somebody who's seriously ill if, by giving them temporary treatment, and we'll talk about that a bit later, they will be returned in a responsible manner. And also you don't want to send people back from France to Mali if you know that he's got a residence title in Spain, for example. Now, all of these rights and can only function if you have the right to be heard. And again, 41 makes sure that not just that if the person involved is heard and he says, look, I've got a residence title in Spain, but I haven't got a pass with me, or I haven't got the decision with me. If it's not properly administered in Spain, Spain is not causing, I'm just taking Spain for example, is not causing, is making life difficult for itself, but also difficult for France. In other words, good administration is vital also, for example, within the Dublin system, so that you can check the assertions of the third country national, and you can quickly make a decision based on proper information. And 41, dear people, I will use today a bit like a mantra. I will come back to you back and back and back again. It means also that the individual has access to the case file. That might be a nuisance, but on the other hand, it might make life a lot easier for you or for the individual, because he can point out to certain facts in his case. For example, with regard to non-refoulement. You don't want to send people back to a country where you will run a real risk. He or she must be able to analyze all the evidence which is in the file. That's a procedural safeguard which is useful not just for the administration, but also again for the individual. Because he might be able to rebut the information which is there. And you know, in my practice, I've quite often seen documents, or I've seen certain documents from certain countries saying, you know, he was in our country, and I took the case of Gezelbas, which was just delivered 2 weeks ago, and the whole point being, if he had known that the Dutch was going to send away to France the fact that he had a French visa, but he'd been outside the EU, if he'd had possession of the file, he would have been able to bring forward his information more quickly, and the proper application of Dublin could have been a fact. Also, it's important to remember that under 41, a careful and impartial examination should take place by the authorities. And a careful and impartial examination is not something abstract, it is something practical. Because, there you go, in the decision making, the decision should demonstrate that there's been a careful and important impartial examination of the facts. Article 12.1 says that a written decision is the cornerstone of the procedural safeguards. And again, that is important because you know, we're so interlinked, all our asylum migration networks are so interlinked. If it's not in writing, then life becomes very, very hard. Article 12.2 says that a written or oral translation of the main elements of the decision should be provided upon request. If you don't speak the language, and it says here upon request, I have a bit of a difficulty with that. If you only speak Farsi and you're left in country A, B, C, how can you make clear to the authorities that you want it if you don't have a translator? And we'll talk about the right to linguistic assistance a bit later. There are a few countries or member states who seem to think that the right to linguistic assistance is a one-way street. We tell the individual, with the aid of a translator, what we're doing. That is not I think, a correct approach. Also looking at the Common European Asylum System, it's a two-way street. The asylum seeker or ex-asylum seeker or illegal or what have you not should be able to talk back. And, for example, make known his request that he wants a written or oral translation of the main elements. The third part of Article 12 says that the use of standard forms is limited to third country nationals who have illegally entered the territory and who have not subsequently obtained an authorization of a right to stay. I think this is a very practical paragraph which in principle I don't have a problem with. Sometimes you come across, I mean, I work also at the Amsterdam airport as an acting lawyer, so sometimes you come across people who should definitely not have been there in the first place, but anyway, they're there. Some of them come in with visa, some of them they come in with, for example, fake visa and so forth, and that is a crime, so they would fall under the illegal entry. And if they have the choice of either spending some time in border detention or going back, most of them are absolutely fine with going back to whatever country they come from. Nigeria, for example, we've seen a lot of examples where they use fake documents. And in such a situation, the returns decision, can be limited. However, if they want to ask for asylum, the fact that they're asking for asylum makes their stay legal, which means that if you still want to return them, despite this situation, you will have to do more. then use a standard form. And by the way, a written decision is a reasoned decision. If you have, in my view, and this is also what the court has said, you've got to have reasons in order to make sure that a written decision is proper. Albeit that the court in, I think it was GER case, the ECJA has said that there is a margin of discretion, and which I think is not a problem as such, if you, as long as you safeguard the rights which are there under Article 5 of the Returns Directive. Again, best interest of the child, family unity, the non-refoulement, and the health issue. Am I doing on time? As I said, the right to be heard is part and parcel of the right to an effective remedy. And Article 13 underlines this issue, that effective remedy should be provided as regard all decisions related to returns. I've seen, for example, where I was in the Balkans, that you have a huge amount of little administrative decisions. I'm calling them little not to as a derogatory term, but some countries have a fondness for bureaucracy and administrative complexities, which is very, very difficult, including particularly our own country. And you have sort of minor decisions who have suspensive effect, who doesn't. In the end, and I think that's quite good, the Returns Directive is clear, all decisions related to return. So there's no qualification and limitation on that. Thank you. And the appeals bodies must have the power to suspend the enforcement in individual cases. As it's clear that this stems from the Article 47 right, the right to an effective remedy. And the right to an effective remedy under 47 Charter equals Article 6 of the ECHR, and thus the appeals bodies must be able to do something. And particularly if you're dealing with a group of people where it's not clear whether they're asylum seekers, closet asylum seekers, illegals who might want to ask for asylum, and you have the whole bunch taken together, and you don't know as an administration what you're dealing with, better safe than sorry when dealing with non-refoulement, which means a suspensive effect in order for him or her to be able to have at least a chance to put forward his information and to speak to a lawyer. Okay. Article 13 of the Returns Directive, as it says, should be interpreted with Article 5, I already talked about that, and Article 9. And it obliges the reviewing body to grant ipso jure suspensive effect if the principle of non-refoulement is at stake. This has been discussed quite often. If non-refoulement, in my view, is at stake if we are inspired by ECHR case law, as soon as there's an arguable case under Article 3. The threshold should not be real risk, because then you're already there. The threshold should be an arguable claim. If you look at Gebremidem, Sultani, MSS, arguable claim is enough. Arguable claim kicks in the obligations under Article 13, and under Article 13, suspensive effect needs to be there. And also, national authorities should not want to send away people who have an arguable claim. You need to investigate that. And I'll come back to that when I talk about the Abdida decision a bit later. Again, let me emphasize that Article 12 of the Returns Directive and 13 applies to all returns decisions. So non-refoulement is a reason why you can suspend. There's a recent case which is, just put it up as up in the air, a Belgium case called the Nyanga versus Belgium, not versus Belgium. It's the Belgium judge which referred this case on the 11th of April, and it's just, I just read about it, thanks to Karin. I think it's a very important issue which the court has asked about. Basically, it says in the summary, it's quite limited. Article 5 of the Returns Directive, read in conjunction with 47, there you go, as general principle of EU law, as applied in the context of the directive, to be interpreted as requiring national authorities to take account of the best interests of the child, family life, state of health, third country nationals concerned, when issuing a returns or removal decision. This question doesn't look that interesting, but the case was very interesting because it concerned a person who asked for asylum. Asylum was rejected, and with the rejection of the asylum, also a returns decision was given. Now, this took a lot of time, and in the meantime, he got into a relationship, and he had a child, or they had a child, after the asylum case was finished. And he asked for a residence permit based on the fact that he had a Belgian child. And one of the issues was that the Belgian authorities said, well, you know, we already given a returns decision. Should we need to look at the case again or not? Well, the Belgian authorities said that there was no need because the decision had already been issued. And then the Belgian judge said, well, you know, that's questionable, you know, because there are new facts. And in other words, if Article 8, the right to family life, ECHR, is applicable, and 8 is an ex nunc decision, you know, looking at the case now, then surely the fact that he has a child, a Belgian child, should be included in the decision making. And the judge was, I think, quite careful to say, you know, it doesn't trump a returns decision per se, and it was quite modest to say at least take it into your consideration. And it'll be very interesting to see if you combine that with the right to a suspensive effect. You know, it becomes quite clear that the returns directive might lead to a situation that, you know, third country nationals who have been staying in your country for a long time, actually their life doesn't stop. You know, this is not a no. I think it's a no-brainer, but yes. So they will have relationships with people, and yes, if there are children which are the result and who have rights also, then at least the government should be able to be in a position where they encompass this information when taking a decision. And I would expect that by the end of this year we ought to know more on this. I already mentioned the Abdida decision of December 2014. Again, Article 5 and 13 of the directive, I think were important, but it also said in conjunction with Article 19.2 of the Charter. And it precluded national legislation which does not make provisions for a remedy with suspensive effect in respect of returns decisions whose enforcement may expose the third country national to a serious risk of grave and reversible deterioration in his state of health. You can go a lot of ways, but one of the interpretations, if you look at the threshold, which is huge, grave, irreversible deterioration of his state of health is not anything new. This is almost like D versus UK, the ECHR decision, the St. Kitts, the HIV dying man. So in fact, what you see here is that Luxembourg is applying Strasbourg case law in the interpretation of non-refoulement, which I think is completely logical, because non-refoulement in Article 3 is equivalent to Article 4 under the Charter, so there's no reason why you should not apply the D versus UK test when deciding on this issue. I talked about linguistic assistance. I think it's a vital issue, and I'm glad that the Returns Directive gives some positive obligations in this field. Because if you can't talk to your client as a lawyer or in administration, then you have a big problem. It implies not only obligations to provide for a translation of the decision, but also an obligation to make available assistance by interpreters in order to allow the third country national to exercise his procedural rights. In other words, what I called before, it's a two-way system, not a single-way system. You can see that as an obstacle, but you can also see it as a friend. in the sense that you would want, under good administration, to get all the information in from these individuals in order to enhance and to safeguard the quality of your decision making. I just put up the Chonka or Conca versus Belgium decision. It's an oldie from February 2002. Chonka is also, I think, a very important decision, not just because of the linguistic aspects, but also on the manner in which, prior to the Returns Directive, expulsions were taking place. This is not what you would want to be doing, people. Which in the Chonka case, Roma families were basically lured into the police station under false pretenses, put in detention, and they were all going to be carted off, I think back to Czechoslovakia, but I'm not sure to which country it was. The court was quite clear. It looked at the practice. It said, because Belgium had said, yes, but there was an interpreter. Yes, but there were lots of families, and there was only one interpreter. And that creates such practical problems that the right to effective remedy seriously becomes impaired if this is what happens. And I think it's an important decision for advocates, lawyers, but also for states to recognize that the court will look at the facts. Sometimes in Holland we have these sweeping operations where illegals are being gathered and sent back. If on that day I'm very, very lucky and I have to work, means I've got lots and lots and lots of cases because it's like carting off, I will not have an interpreter. Why? Because the Dutch Returns Department or the Immigration Department will have hired all of these interpreters, which is quite logical because they have to do all the individual assessment of these people as well. And if it's a language which is not very often used, then you run into problems. And this is quite understandable, and I'm not challenging the fact that these interpreters are used. My problem is that if I can't do my job properly because all of the interpreters are being used, at least give me the leeway as a lawyer to make sure that I can do my job as well as the administration. And Chonka was, in that effect, I think, a very useful case, which I love to cite whenever that happens. Legal assistance and legal representation. Article 13, I was already talking about that. 4 says that the member state must provide both legal assistance and representation free of charge if the conditions foreseen in the directive and the national implementing legislation are met. There you find the snag, if conditions foreseen in the directive. And the directive can be quite limiting, and also national legislation can be. However, the conditions which may be imposed must be read in conjunction with the reference to 20 and 21 of the recast Asylum Procedures Directive. And here again you can see the interlink between the Common European Asylum System and, at the end, if it is asylum seekers we're talking about, the Returns Directive. They're almost part of a same system, or they overlap. And I think it's very important that asylum seekers, but not just asylum seekers, third country nationals, have the opportunity to learn what their rights are. But also as a lawyer, I might be able to explain to them that they've got unrealistic dreams of what's going to happen to them once they arrive in Europe, you know, and that certain rights are not there, and that the path that they're following now might not be a good path. While if they go back to their country, it might be a lot better for them to start afresh from their country of origin and ask for a regular residence title, because they have the idea, yes, I can't, you know, some asylum seekers, for example, have the idea that economic well-being is a reason why they have well-founded fear of persecution. You know, I can quickly help them out of their dreams. While if they have a cousin who's also living there, I'm just giving you some examples, who might be able to put them up and allow them to work in their family business, it will surely be preferential on the Article 7 voluntary return of the Returns Directive for this person to go back and to do it in the royal way or the proper way, rather than try and go through a hopeless asylum system. So lawyers are not all bad, put it this way. or some lawyers are not all bad. As I said before, when a decision not to grant free legal assistance and representation is taken by the authorities, in other words, the administration, member states shall ensure that the applicant has the right to an effective remedy before a court or tribunal against that decision. That might sound a bit like Alice in Wonderland, but it's quite clear that in order, if you don't agree that you don't have free legal assistance, then you ought to have a channel to put this forward. This is under Article 6 and 13 ECHR, and thus also under 47. So this is, in fact, as a result of 47 in that field. Yeah. Non-returnability. I think that's a very important issue in the Returns Directive. If you read the book, the fabulous book of Fabian Lutz on the architect of the Returns Directive, he basically says there are two flavors, no more. And there's no gray, there's black and white. Either somebody is returned, and if somebody is not returned, he should be legalized, or he or she should at least be given some form of documentation to prove that he's not able to return. I love the theory. The practice is a bit more problematic. Why? Because the moment of the decision whether somebody cannot be returned, in practice usually moves up and up and up and up and up and down. Say, oh, we're still looking for possibilities to send you back. Oh, you know, only give us 2 more months, give us 3 more months, and I'm sure your national government will help. Or you are lying because you say that you're from country A and in fact you're from country B. These are the practical problems that we as practitioners run into, and I'm sure that you as policymakers also have to deal with these challenges. And in that field, procedural safeguards are in fact, as I would call, a friend, because it will make sure that the person is informed, the person knows what his rights are, the person knows what his possibilities are, and then he or she might be able to bring forward the information which he wants. One of the most problematic issues, I think, are ineffective entry bans. Ineffective entry bans just for third country nationals. It just doesn't help. You just make them more illegal and you can't send them back. And very problematic, and I specialize in my asylum and migration also on the position of Palestinians. How are you going to send somebody back to Gaza? You're not going to send somebody back to Gaza because since Morsi has been taken away and al-Sisi is the president, and that's not just me being, I don't know, left-wing Guardian-like commentator, but this is a fact. There are no returns through Egypt. And you can't get to Gaza in another way. Well, you can go through Israel, it's not going to happen. Through Egypt, it won't happen. And through Jordan, you can't, because you can't go from West Bank to Gaza. And many asylum seekers or former asylum seekers are basically stuck. And there will be issued entry bans or returns decisions which are not effective. And the amount of my clients who get picked up on a Friday afternoon, they say, you say you're Palestinian, but I think you're Moroccan. And by the time it's Monday morning, the police say, oh, yes, you are Palestinian. That is harassment, however way you want to call it. If these clients of mine had a proper paper saying, look, this man cannot be returned, at least he'll be spared the embarrassment of having to spend a weekend in jail for what? For nothing. Because the police didn't have time to process his file. So that brings me to the safeguards pending return. Article 9 describes cases in which the removal of a person must be postponed. And it has 2 parts. One part is shall not be returned, and the other part may not be returned. It is important, particularly in the case that I just described about the Palestinian, but you can take Roma or you can take other situations, that this is actually properly processed in the system and that people are given documentation on this issue in order not to be spared the embarrassment of having to spend a weekend in jail. And that's why under Article 14.2, it is very hard to get member states to actually provide a written confirmation of the situation. And I'll be very interested in you working also in this field, to give me some examples of when in your respective jurisdictions these documents are actually issued and how they are issued, what format you're used, in order to make sure that arbitrary detention doesn't take place. It should be borne in mind that the Returns Directive leaves member states, as I said, the choice of either issuing a returns decision or even granting permits to regularize that person. Lutz said it quite accurately, either it's black or it's white. We don't have any gray anymore under the Returns Directive. And I think it's very welcoming that the Commission recognizes the situation and that this is proposed to provide for a minimum level of conditions of stay for these illegals while they cannot be returned. Because, and then you think, where did this quote from Merkel come from? Well, let me go. If you have an obligation under the Returns Directive, then that obligation also encompasses more than just the meager and the very slim D versus UK terminally ill AIDS people. If you're looking at, for example, the children of Palestinians, they ought to be able to go to school. They ought to have some form of normalization in their life. This right to a written confirmation was emphasized in the Mahdi decision by the court in June 2014. Member states must, in such case, not may, provide the third country national with a written confirmation of his situation. And the right to social assistance, which flows, I suppose, from Article 1 of the Charter, the right to human dignity, is a natural consequence of this. And I would like to ask your attention for the report made by the Law Clinic of the VU, Amsterdam University, on the forced to leave but nowhere to return to. The rights of non-returnable stateless Palestinians in the Netherlands. It's in English, so everybody can look at that. It gives a very handy overview of all the relevant legislation. And you can, if you're using, and this obviously is not limited to Palestinians, but also to other people who are non-returnable. And it's on their website, so I would gladly ask you to look at that, particularly because I think the Abdida decision of December 2014, even though it's good, is quite meager in the sense that only a right to some form of reception conditions is there if somebody is seriously ill. And you sometimes see in practice the irony that somebody is not seriously ill enough. So we first kick him out onto the street, then he becomes seriously ill, and then we can provide him with information. Why? Because this is how the system works. I think that from a standpoint of legal order, of communautaire legislation, is not good enough. We ought to be able, as the EU, to make sure that ill people don't become so very ill in order, and only then to be provided with adequate care. Because, well, I can't read it again, Merkel says, when it comes to human dignity, we cannot make compromises. There you go. As I said to you before, the general applicable conclusions in Abdida are the principles listed in Article 14.1 must not be interpreted in an isolated way, but always within the context of fundamental rights and dignity of the person concerned. Para 42. So that gives a lot of room for administrations, for example, to bring in the best interest of the child, to bring in family unit, whereby parents and children get a place to stay, but the 18-year-old daughter doesn't, because she's 18 and she can take care of herself. You have all of these situations which you really want to avoid. And thus it can be argued that, also according to Article 1 of the Charter, at least the basic needs of third country nationals who are not able to return must be satisfied unconditionally. And unconditionally means unconditionally. That was it.